Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's start in East Cleveland. I don't understand this for a lot of reasons, but
I do. I lived it.
Okay. So here's what happened. So the Ohio Court of Appeals has just upheld a 1.6, and this won't be the end of it, $1.6 million verdict. There will be more with attorney's fees, et cetera, because the city violated the minimum staffing requirements in the CBA. I don't need to say much more than that, other than, look, back in 2016, they reduced it. They lost. They went through hearings and appeals and arbitrations, and there were some temporary reversals, some hiccups, but they corrected it with another arbitrator and another hearing. In any event, after 6 years, the city has now been ordered to pay back pay and or damages, et cetera, for non-compliance. I mean, fines and penalties. What is really interesting, all because they reduced the staffing below the bargained and agreed to amount in the CBA. So I won't get too much more into this, except there are some really interesting things. First, in Ohio, apparently you can fine and award punitive damages against the city. You can't do that in a lot of states. A lot of states are immune from penalty type damages and fines. So this was really interesting that a court would award that. Nonetheless, they were fined like $750 a day for a lot of days of non-compliance.
But Brad, this was contempt of court. This wasn't a fine issued by the arbitrator or the state labor board. This was a fine issued by the court. The court ordered them to increase staffing, and the city went, and the judge said, "Oh yeah, $750 a day for not complying with my order." And then they still didn't comply. They went like this, and now it's $1,250 a day.
Right.
So we're talking about contempt of court there. And now there may also be, as you suggest, there may also be some additional damages related to the lack of staffing on those days that, typically in a collective bargaining environment, if you're supposed to pay two people extra a shift, the typical arbitrator's award on top of this is going to be, you got to pay the union that amount there. Right. Because now they were supposed to have 10. Now you only had 8 people doing what 10 should have. So the people who were working should get some, their workload went up. And so I said that I lived this. I've seen municipalities do this throughout my career. And it's gambling with other people's money. And I got into this a little bit in the blog, but when you own your own business, if you make a decision and it costs the business money, it comes out of your pocket. Well, that's a big boy decision that you make as the owner of the business. But what happens when you don't own the business? You're gambling with other people's money, right? And so you're rolling the dice. And in this case, with a revolving door of elected officials, you have somebody who's the mayor or the city council, whoever is running the show in this particular community. They make a decision in 2016 saying, I'm not going to be around by the time this thing is. We'll just have our lawyers fight it and appeal and stretch it out. I'll be governor by the time this thing is heard. So who cares? No, seriously. And
it's a great.
And it's not right. And I get into a discussion with somebody about this, saying, well, why should the taxpayers be responsible for this? Why? Because if they're not held accountable for breaching a very clear agreement, they or someone else are going to do it again.
Yeah.
Because there's no consequences to it.
And so that's the problem. That's the problem with holding municipalities in contempt or fining them or punitive damages, why a lot of courts won't do it, saying we're not going to burden the taxpayers. But if you're not, in my opinion, if you're not going to do that, then fine, you pay it.
The bottom line is, if you don't hold them accountable, they're going to do it again, and they're going to keep doing it, and they're going to ignore court orders. They're going to ignore collective bargaining agreements. You're going to have labor strikes. I guarantee you, 1.6 million. That seems like a lot, and it is a lot. The labor discord that's created by this kind of nonsense, in terms of firefighters stretching out injuries, going off injured for things that when people are happy and productive and feeling like they're valued, they don't go off injured. They just suck it up. All of the additional costs dwarf that 1.6 million. And those are all hidden. Those are all hidden. They're hidden in workers' comp. They're hidden in overtime. They're hidden in a lot of different things. Okay. Right. In grievances, in other lawsuits. So you can't calculate the harm that this kind of nonsense causes within an organization. And I say that from experience.
What I guess where I started is, how are you going to win? You have an agreement. I'm presuming the agreement was pretty straightforward. From what I read, there weren't too many ways to interpret the staffing level, and the city admitted we're reducing it. What are you debating? I want to know from the city, what were you thinking when you blatantly violated the CBA?
They're thinking we're going to fight it and we're going to make them drag this out, and maybe our economic woes will be over in a few years, or I won't be here, somebody else will be here and it'll be their problem, but I'll get through this year.
Yeah.
And again, you can't do that when you own the business. You can't do that because you're going to have to pay the piper.
Right.
In municipalities, they don't. And I think maybe personally, and I put this in the blog, maybe it's time to hold elected officials personally responsible, almost like a fiduciary of a corporation, where if you're a fiduciary and you pull a stunt like this, you're a CEO of Coca-Cola, or you're on the board of directors, and you're involved in this kind of nonsense, and then you leave the board, you could be personally liable for breaching your fiduciary duties.
Should be.
So, that might be an alternative here. But I've lived this. I've represented unions in this situation. I know the lawyers on the other side, and I know the kind of antics that they pull to drag it out, and meanwhile increase their own fees while they're dragging it out. And it's just, and who pays? The taxpayer pays. And
you've got no good faith basis. Hence, again, punitives, fines, etc. So, okay, we won't go on, but I think if Curt and I could cast stones at the other attorneys for doing, violating the CBA on a question of interpretation is one thing. There was no interpretation. That's one thing,
right? Absolutely. And by the way, something I didn't put in the blog, this city apparently pulled the same stunt in 2009 when they went from 12 down to 10. There was a big several lawsuits and grievances and everything when they went from 12 to 10. Now they went from 10 to 8. Maybe if the courts had held the city responsible back in 2009, maybe the same cast of characters might not have said, hey, let's do that again to save a little bit more money.
And hopefully what you don't see here is retaliation against the union saying, well, I guess we don't have any more training money. So, because you sued, we have no more training money, which would be another cause of action, another suit, right? Retaliating for enforcing rights. But
no doubt elected officials will be pointing the finger back at the union saying, they're why we're in such, that this is why we don't have money for school books. This is why we don't have money for this or that. And not really, saying, yeah, we own this one. We screwed this up.